Just believe us, we trying to teach you the rights to read you. It's just procedure, baby.
Trials, instruction, procedure. AWS gon' teach ya. Trials, instruction, procedure. AWS gon' teach ya. Here's a tip, don't get it twisted.
Welcome to Attorneys with Swag, the show you come to watch to learn about the law. My name is Eugene Toussaint, your host, and I'm here with
Charles McCracken, he, him.
Eric Margolis.
And Dannelly Rodriguez, the people's lawyer.
And on this episode of Attorneys with Swag, we're talking about housing court, navigating housing court, and how to avoid eviction. So, guys, tell us about the kind of law you guys practice and what the audience needs to know.
I practice eviction defense here in Queens. Before I went to law school, I worked in Department of Homeless Services in a team called the Home Support Unit in the mayor's office, where my job was to find apartments for people who were living in the shelters. Did that for 2 years, started law school. Now I work in eviction defense in Queens.
Nice.
I'm from outside Philadelphia, go Birds. Moved up to New York to go to law school. Went to St. John's with Eugene. Been practicing housing law for about 10 years now. I work at an agency that specifically assists the elderly in homelessness prevention. And as of recently, we've taken on some right to counsel cases as well.
Okay.
Awesome. Yeah, man. Donnelly again. I'm from Astoria, Queens, born and raised, and I am a public defender in housing court because housing attorneys are public defenders, specifically in the right to counsel program. So I do eviction defense, and I also do TRC works, which is part of the Tenants Rights Coalition, where we do affirmative litigation against landlords, collective HP actions representing tenants against their landlords for failure to make repairs, not being in compliance with rent stabilization codes, filing complaints with the Department of Homes and Community Renewals, just outside doing the people's work, making sure that people stay home and that they live in dignified conditions.
And what's TRCs?
Yes, Tenants Rights Coalition.
Okay.
Yes.
What is that?
So the Tenants Rights Coalition is a coalition of attorneys and organizations that work to hold landlords accountable for repairs in their buildings. So we represent tenant associations throughout the city who want to hold their landlords accountable with respect to repairs and a variety of different things, because a lot of buildings might not be in compliance with their rent stabilization law and various other different things, and we make sure that they are.
Okay. All right, so I guess we should start off with, here in New York City, and I don't think this is how it's always been, but in housing court, you have a right to counsel, right? How long has that been in place?
The right to counsel, from what I understand, was a coalition that formed around 2017, 18, and I believe in 2018, they passed the right to counsel bill here in New York City.
Oh, wow.
Yeah.
So what was it before that?
It was, there were agencies and they would get, referrals. Like my agency was around for, prior to that time. And, since it was elderly clients that we were mostly dealing with, we got a lot of our cases through the Assigned Counsel Project. Okay. So anybody who was in housing court who is over 60 years old could get referred to us. And we would take cases on, kind of need basis. But, there just weren't enough attorneys to take all these cases. And, we really did see a lot of tenants go through the housing court process without attorneys and just get, swept away.
What's so funny is I got evicted when I was in law school, actually, because I was dumb enough to get an apartment in Manhattan. But I didn't with the money, because they give you money to live. Yeah. What's it called? It's like cost of living, like a loan. You get a cost of living loan. So I was living in Manhattan, and then what happened was I got a cost of living loan, and they give you a certain amount of money, but they said, hey, if your rent is more than what we give you, you can just apply for an increase. So I'm like, oh, okay. So my rent was like $300 more than how the math shaked out. Then when I went to go apply for the increase, it turns out they was only giving me that amount of money for 10 months at a time. So they didn't increase it 12 months times 300. They only increased it. So like, I was like, and then plus like, I was like down like a couple $1,000. So I ended up getting evicted before our first 1 hour summer job. But I went to housing court, and then I literally just went into in front of the judge and say, I can pay it. And he was like, okay, get out of here. They just gave me a schedule.
Yeah.
But now everyone gets an attorney. How does that work?
Well, not everyone gets an attorney. It's not a fully funded program. So at my job, we have 1 day a month where we're on intake.
Okay.
And that means that that's a day where our attorneys show up and we take 3 or 4 new clients, and those are our 4 clients for the month. But we also have another day where we're on intake, and that day we do advice only, which means that person meets with a lawyer and just talks with them for like an hour, and that's the end of it.
Okay.
Because we don't have enough attorneys and we don't have enough money to take on everyone who needs a eviction defense lawyer in Queens.
Okay.
Yeah,
So
we do that as well.
Yeah.
So I guess the first time someone appears in housing court nowadays, will they have an attorney or will they get assigned an attorney at a later point?
So that all really depends, and it seems like a lot of the legal service organizations have their own setup in terms of how they go into it. However, just broadly speaking about the right to counsel program specifically, the people who qualify, it depends on your household size and your income.
Okay.
And it's for people who are at the federal poverty guideline, right?
Yeah,
So
that's really low.
and we know that needs to be updated, and it's classist and it's racist, and that's a conversation for maybe down the line. But specifically, the program is meant for indigent folks. It's not per se like the right to counsel for a criminal defense attorney, where, right, across the board, if you can't afford a lawyer, you'll get one. Constitutionally,
Yes.
this is actually just a city ordinance that gives you the right to access an attorney, and it's called the Universal Access Counsel, right, program, UAC.
Okay.
So you're not guaranteed an attorney. The way it's set up is legal service organizations come in, they schedule days with the court to come in and conduct intake, and on those days, we speak to clients, we provide advice on the spot, and depending on whether or not they qualify, we decide to take them up for counsel.
And what is the quality? Because I know sometimes when I get in, as the audience hopefully knows, I'm a public defender and criminal.
Yeah.
And sometimes I'll get in front of a judge and typically this only occurs when they make like a large bail, right? Like I had a client the other day made $50,000 bail, and the judge wants to be like, "Oh, does he qualify?" And they'll ask me if I looked into it. But it's like it's not being pressed on every case, and it really, to me, it seems like if you don't do something that obviously makes it seem like you make a lot of money, such as pay like a hard bail, no one's really going to press the issue.
Yeah.
Do they press it? Like, what's the standard in terms of pressing whether you qualify or don't qualify? Like, what's the metric?
So I imagine you guys experience this too, but Human Resources Administration, HRA, are the ones who decide that. So before they even come to us, HRA does an intake to see if they qualify or not, and then ultimately they come to us. Now, we provide counsel on the fly whether or not they qualify, but full representation is explicitly reserved for people who financially qualify, and HRA signals to us whether they qualify or not.
Yeah,
now, to the extent HRA is discerning this in any meaningful way, I don't know. That's not my prerogative.
Yeah, and there's the added issue of, you have, decent amount of people who qualify for the services, based on their income or, household composition, but there's not enough attorneys to handle all the cases. So, we unfortunately have to turn down people who do qualify, and we have to, pick and choose based on, impact and,
So what would be like
different
the best? Let's say I'm someone recently get an eviction notice, or there's some other issue. Because I know it's not just evictions, and we're going to discuss that next. What would be like the best strategy to ensure an attorney? Is there like a certain day to show up? Is there like a one thing as compared to the other that would be more strategically advantageous?
I think it's fact specific. At least for our agency, we like to preserve, rent stabilized and rent controlled tenancies. We like to preserve long-term tenancies. And, unfortunately, there's a lot of cases that come into housing court in general that you're not able to keep that person in their home. So those are unfortunately lower priorities. So the cases where we really can save somebody's home, those are the ones that we're going to prioritize.
Yeah, it's really a luck of a draw. I'm not the individual deciding this. My organization is, ultimately speaking, but I would like to highlight the fact that, as you mentioned, that there's not enough attorneys. I would like to flip it, is that they're doing too many evictions, right? And this is also an issue that the state has failed from a policy standpoint. The city has failed from a policy standpoint. We're living in a quasi-post-pandemic world, right? Where we haven't necessarily transitioned out of this pandemic. And it seems like the courts are operating as if that never happened, right? The city and the state is operating as though that had never happened. So we have so many people, right, who are without income, right, who are elders, who lost their jobs during the pandemic, who now can't get a job, might be undocumented and can't get a new job, and now they're just left behind in so many different ways. So I think it's important to highlight the fact that yes, there's not enough attorneys, but why isn't there enough attorneys? Why? Is because the city and the state has failed on a policy level, right, to make sure that people are housed after a pandemic. They tried the emergency rental assistance program, they tried the eviction moratorium, but all those things are now.
Yeah, and now the good cause thing, it's not enough.
So so that's like something that just passed, right? What's that terminology of it? It's a
Good cause eviction.
a statute.
Right.
Okay, and explain that to the audience.
So it applies to market rate apartments because if you're rent stabilized or rent controlled, there's already that built in that there needs to be good cause. So it's pretty nuanced. It depends on the year that the building was built, when they last got their C of O, but it's trying to keep people in their homes that are market rate and kind of cap the amount of rent, but it's not enough.
And it basically means that, like, if they're going to evict you, they would have to have good cause to evict you. It can't just, they have to increase the rent at a certain rate, and basically give you like first rights to continue your lease.
Right. It's important with how the renewal lease structure is.
Okay.
So I think a good way to really look at it, to simplify, is in New York State we have the rent stabilization law, and you are guaranteed a lease no matter what. The only way you don't get a lease is if you're a nuisance or if you don't pay the rent, right? Non-payment or a nuisance. And there's other little things here and there, but those are the two fundamental ones. Good cause expands that not just to the people who live in rent stabilized buildings, but to all buildings. Specifically, the buildings, from my understanding, is where landlords own 10 or more units, right? So it doesn't have to be one building, my understanding, correct me if I'm wrong, but it's 10 units. If the landlord's 10 units dispersed amongst however many buildings and a couple other different provisions, they are subject to good cause. Good cause is non-payment. Good cause is breach of lease for nuisance or other reasons that are outlined in the lease. So ultimately, in theory, it's great because now if you pay your rent, you have the right to a lease renewal. The issue still remains that it wasn't expanded to everyone. I'm of the opinion they should have just expanded the rent stabilization code.
Why not?
Right? And now there's also this sort of threshold question. It's not a limit, and I looked at it, of how much they can increase the rent. They say it's a threshold of 5% or the CPI,
so I think
Consumer
it's like,
Price Index.
it's somewhere around like 8%.
Whichever is higher,
Right.
I understand they're allowed to increase the rent by, but that's just a threshold because it gives the judges the discretion, if the landlords increase it beyond that, to justify that. And justifications for that are conditions that need to be repaired. Like, look at the buildings. Look at the stock. These landlords intentionally neglect these buildings and these apartments. So I don't see it as robust as the rent stabilization protections, because the rent stabilization code is you cannot increase the rent beyond the Rent Guidelines Board, period. That's the amount. No judge gets to decide if there's a justification for an increase. So the law is, although like it's going to expand and help a lot of tenants in the city, there's a lot of room for question marks, because I mean, we've been in housing court and these judges are, for the most part, in my opinion, like beholden to the landlord bar and the landlords community here in the city.
Without a doubt.
So like taking a step back, so what are like, just to like ingratiate the audience for what we're talking about, like what are the most common cases you guys are getting on a daily basis? What's a common life of a housing court attorney?
I mean, there's the non-payment cases, which, are pretty straightforward. Somebody fell behind in the rent. They owe the landlord money. There's programs out there such as the One Shot that are there to assist people who are in
That thing's impossible.
cases.
I probably do that shit.
Yeah, I mean,
That shit does not
it's
work.
a lot, and they're really bogged down with the applications, and I've seen so many applications just get kicked for no reason, and I have clients that have to apply 2, 3, 4 times before they even get the application in front of somebody who's going to review it, and then there's struggles after that point too.
Yeah.
And is that also defined as a holdover? Is that the same thing?
No, so that's just to take care of a non-payment case. A holdover is a for-cause eviction. So, like the nuisance cases that we were speaking about, if someone isn't a leaseholder, and that'll get us into the whole succession mess. But there's a couple different things that we see pop up pretty regularly.
Okay.
Yeah, so just to add on to what you were saying earlier with the one-shot deals, I feel like one of the biggest inefficiencies in housing court is that we have these people who are entitled or eligible for government benefits, but then the struggle of getting them those government benefits becomes an issue for the housing court attorney. So it becomes a responsibility of my role as a tenant advocate to get money for the landlord from the government. When this whole thing could have been resolved by the landlord going to the government, or the government being more proactive and helping this person get the benefit that they're entitled to, and keeping this whole case out of housing court. And it ends up with me having to take a client that I'm able to help, thank God. But still, this is something where if the city was more proactive, or if landlords were more active in trying to use government benefits instead of going straight to housing court, this case wouldn't have come here and I'd be able to help someone else.
Yeah. And that's by design.
Yeah.
That's by design, because you can't access the one-shot deals and the city FEPS programs unless you are experiencing eviction. So it almost always falls on the RTC attorneys, right, to now become not just litigators, but also social workers, and specifically trying to get benefits for our tenants to make sure that they can continue to live in their apartments. So we're doing more than just litigating. We're filing the motions, we're doing the pretrial motions, we're doing the arguments, we're taking cases to trial, and we're collaborating and working with HRA and the various city agencies to make sure that the tenants actually get the money paid out, because that's the issue 9 times out of 10.
It's happening with subsidies too. Something happens with somebody's Section 8 voucher, even on an administrative level, that causes a problem. The landlord brings the tenant into court for it. It happens with SCREE, which is the Senior Citizen Rent Increase Exemption. And it falls on us to take care of these issues that, it's really not proper for us.
Yeah.
So, not to go too much into you guys' specific jobs, but like, is that something that is truly handled by the individual attorney, or do you guys have social workers that like absorb those responsibilities and kind of like, I deal with the legal stuff, and then, because I know at my agency, if I need a social worker, I can basically, I have to make sure that the social worker is on top of it, but I can basically focus on other things. But is it really falls on attorneys when it comes to housing court?
Yeah, my office, we don't have a social worker. Like,
Shit,
I've had
that's
clients, yeah, so everything handling like benefit advocacy, like I'm emailing HRA directly to argue about like, hey, I applied for this one-shot deal the first time and you declined my client. We applied for the one-shot deal the second time, you declined my client. Now we have the third application. You didn't tell me why you declined the first 2, so like I don't know, and this guy is still eligible, so like what more do I have to give you? That's all on me, on top of all of the legal advocacy that I have to do and all of the other clients that I like, that my role requires that I advocate for. And I've had clients call me like in straight up panic attacks, and that's just, there's no one else to hand that over to. So I'm sure you've had the same experience where you're not only just helping someone's legal issues, you're also helping them emotionally because they're going through a freaking massive trauma. And you're also helping them with their government benefits access.
And so I guess what is HRA's typical, like, to me, I've made attempts to deal with HRA during some financial struggles, and it seems like it's a black hole. Like, it seems like you apply, they run you through the ringer. I've appeared in person, which was a fucking mistake. Because they look at you like you're insane. Like, I've physically been in that building, got into a physical human being after 4 hours, you're sitting there.
We have to go in person sometimes just to pick up checks, you know, because somebody decided that they don't want to send it to housing court or send it directly to the landlord, so it eats up, you know, resources of the attorneys who could be working on, you know, litigating.
You have to, like, get a ticket number?
We get an email, you know, that such and such client was approved, and we have to, you know, print out that email, go to the HRA office in Manhattan when, you know, we're all in Queens housing court. So we have to take that trek, you know, that takes away from our day. It's
Absolutely.
It's absurd.
That's crazy. Yeah, okay. So it seems to me that they passed right to counsel, but in terms of like the way they treat criminal defense and the way they treat housing court, it's not the same at all. Like, they're not, you guys don't seem well funded or well supported in the way that would allow your jobs to be easy to accomplish on a day-to-day at all.
Yeah. I mean, we don't have paralegals, you know, social workers or,
Again, it's by design. Like I said, there is no civil Gideon. Criminal defense attorneys, you have the constitutional right to a lawyer. So the system is galvanized and empowered in a particular way to meet that demand. It's a constitutional right for you to have a defense lawyer. The right to counsel is just, it's a city ordinance. They tried to make a state push this last legislative session to get the statewide right to counsel. Didn't happen, unfortunately. So ultimately speaking, it's a right. And I'm not going to dismiss the fact that it's a right. But in terms of its legal prowess, it's like, you can't sue someone if you didn't get your right to counsel if you qualified for it. Because in the actual bill itself, it says that you don't have a private right of action for this bill, which means that it's, for all intents and purposes, legally a privilege. It's not treated as a right. It is a right, and it should be a right, and it should be enforced that way. So then, now when you have these systems, the HRAs and the so on and so forth, the one shot, it's almost like a one-shot deal. A one shot at a lawyer. If you come in on the right day and you speak to the right people and you just so happen to get picked up, great, right? But that's not how we should be treating a right to housing, right?
So now, so once you are assigned to the case, it's your case, I guess, because obviously it depends on what the pleadings are, but what is the typical like length of a housing court case? What's typically happening? Like I guess how does it proceed? Like, for example, like in criminal, you know, it's arraignment. They have to give us discovery. Then there's hearings and there's trial. That's basically the gist of it. And what is like how long does it usually take, and what's like the timeline for housing?
Housing court, summary proceedings. So it's the Wild West. You know, there's cases that they, you know, push from first appearance to trial in a matter of, you know, less than 6 months. But on the other hand, I have a case from 2017 that's up to almost 60 appearances.
Okay.
So it really varies.
And what creates that distinction? Like, what makes one last 60? I'm assuming it's what the case is about. Right? And then what makes one, they're like, we're going to figure this out ASAP. Like, I guess, what kind of cases do they ASAP, and what kind of cases do they allow to just flow?
I feel like I want to just zoom out just for a second, because you mentioned summary proceeding, right? And we have to understand what a summary proceeding is to sort of get into that, right? You have plenary actions, which is your regular civil cases and your criminal cases where you have discovery and all these things. In summary proceedings, you don't have a right to discovery. Okay. So that's out of the picture. We're not going through any discovery time, which is probably one of the most lengthy parts of the process. So that's out of the picture, right? So there's the pre-trial part, the resolution part, where the case begins, and the purpose is to sort of do pre-trial motions to dismiss, negotiate potential settlements. You can be there for 6 months in that part, just litigating. You file a motion with merit, of course. You have to set up a motion calendar. You have to brief it. You have to do oral arguments. That can take anywhere from 2 months to 6 months.
Okay.
And after you finish the resolution part, right, if you don't come to a settlement, the case doesn't get dismissed, it gets sent to part X or the trial part.
Okay, but so I want you to continue, but to get you even to that first part, it requires eviction notice?
Yes.
Right?
Well, we're talking before an eviction notice. So let's talk from the very first thing that a client would get would be, if it's a non-pay, they would get a 14-day notice that's called a rent demand, saying, hey, you owe this amount of money, and if you don't pay to us, we'll take you to housing court.
Okay.
And if it's a holdover, they get a 90-day notice to terminate if they've been there for a long time. I think it's more than 2 years.
There's 30, 60, 90.
Yeah,
And then
based on the length of the
There's
process.
10-day notices for licensees. There's a slew of different notices.
Okay.
There's notices to cure if there's some sort of condition in the apartment that the landlord is taking issue with, such as nuisance or somebody has an illegal partition, things like that.
Okay.
So this is even before anybody gets official eviction papers, before a case is commenced.
So all those things we were just talking about are called predicate notices.
Okay.
So you get the predicate notice, and then after the time in the predicate notice elapses, so like the 10 days, the 30 days, the 90 days, the 14 days, you get a notice of petition and petition. And that's the one that says you are being sued in housing court. And if you don't show up on this day, a default judgment will be entered against you. And so that's where you get your first day in housing court. And you go there, and that's where you have your talk with the person who works at HRA, who's in the housing court, courtroom. You do your intake, and if you qualify, you go over to a universal access to justice center. And that's where you might meet with a housing court attorney if you qualify, and you cross your fingers and hope you're being taken in for full representation instead of just advice. And then you'll also get your second court date, because the first court date is just about if you get a lawyer. Then that's your first date where you're represented by counsel, and the counsel, if there's a jurisdictional defense, like they didn't serve something properly, or I just had a case where the client has a Ring doorbell camera, and you can see the process server drive up, look at the apartment door, drive away. I was like, oh, this is the best day ever. Yeah. But I have to write that motion to dismiss based on improper service by the first court date. And if it's not, we show up and we have a meeting with the landlord's attorney about possibly settling this case, or like what our plan is with the case. And from there, you could get sent to a trial conference, like a pretrial conference from there, where the third court date would be pretrial conference, and then after that, you go to trial. Okay. And at trial, if you lose, that's where they get a marshal's notice, or a warrant of eviction, and then the person would get a notice of eviction, a marshal's notice posted on their door, and have 14 days, or the eviction would happen. And then it would be our role to get orders to show cause to delay that eviction date if there's
good cause.
Good cause. Yeah, thank you.
Okay.
It's so
Can you
complicated.
get an eviction notice without under that first part? Because I feel like they give me an eviction notice after a couple months. I don't remember them telling me to go to housing court.
If you don't show up to court, if you ignore the predicate notice and then your eviction notice, then there's a default, and
happens all the time.
It does.
And just as he mentioned, the process server just drove up, looked, and just kept it pushing. And this is a chronic issue where a lot of papers are not being sufficiently served. And it happens all the time when we have to file order to show causes for people who never were served adequately. So they came to court after they saw a 14-day notice.
Yes, exactly.
For eviction.
Yeah, that's what I did. I mean, I knew I wasn't paying. But I was like, when I saw that notice on my door, I was like, but somewhere it was like, you can't go to housing court. I was like, let me do that.
Yeah. Well,
also, I just want to go back to, you went to St. John's.
Yeah.
Why were you living in Manhattan?
You know what it was? I didn't have my priorities.
I lived in South Brooklyn too, so I wasn't doing so good
I was
either.
like, I was having a good time in Manhattan, and I was like, I don't know shit about Queens. I thought the universe put me, my office is in Queens.
yeah.
I think the universe was like, oh, you didn't want to go to Queens, motherfucker, I'll show you. But
They evicted you to Queens. Welcome to Queens, my brother.
yeah. My agency is all 5 boroughs.
Yeah.
I ranked what borough I wanted to go to. It was Bronx, Brooklyn, Manhattan, Queens, Staten Island.
Yeah.
They put me in Queens, and I hit the head of the office like, yo, why Queens? She's like, well, you don't need to work here if you don't want to.
You want the job or not?
I want the job. No, thank you. But okay, all right. So I kind of understood that. So there's papers, and then all those papers can get you into housing court. Then there's this initial process, right? That initial process can be anywhere from 2 to 6 months, and then you said these parts. So take me back to those parts.
So as he was mentioning, once the predicate notice is filed and the expiration passes and they give you the notice of petition and the petition, you come to court, you answer, they give you that first court date. That is the resolution part. That's where you speak to your lawyer. From the lawyer's perspective, that's our time to file a motion. If there's a substantive or procedural defect, we would file that motion to get the case dismissed on those grounds. And in that moment, again, it can take anywhere from 1 to 3 months to argue the motion, right? And then once you argue the motion, the judge has to make a decision. And judges, they've been taking their sweet time, and it's
good sometimes.
It's to no prejudice, relatively
Right.
speaking, to our clients, because what our clients ultimately want is time. So as a litigious civil public defender, a housing attorney, it is our prerogative to file motions when there's defenses, because one, you can get the case dismissed, and alternatively, you're giving your client time to figure out their living situation, assuming there is no substantive defense, assuming that it's a no-cause holdover where you don't have a lease, it's a market rate apartment, and your ultimate doom is you will be evicted. Right, so we're just there trying to, preserve our tenants' due process rights, because that's what it is. They like the landlord bar likes to complain that, oh, we're slowing down the cases, but no, the clients are entitled to due process, and this is what it is, and that can take anywhere from 1 to 3 months, 4 months, 5 months. I got a decision the other day, a year after, right? I moved for discovery on a rent overcharge where I had reason to believe that the landlord was conducting fraud and deceptive practices and illegally charging the incorrect rent to a rent-stabilized tenant. And the judge took a year to write the decision, right? And, there's 2 sides of that coin. One side is my client gets time to figure out how to get the money. Second is arrears is accruing in that time frame as well. So these are the type of things that we have to think about in terms of what's in our client's best interest in that time.
And arrears is back rent, right?
Yep.
Now, I guess what's standard practice? I guess what's standard practice? Wrong word. What's most likely happening? Are these clients holding that money because that's what their responsibility is, or are they going through a lengthy housing court process and then saying, fuck it, let's just settle and I'll leave? I guess, what happened? Because that seems like if someone is barely making it, it seems like a tough responsibility.
Yeah.
I think it's a case-by-case basis. I have clients who, are trying to make any payments that they can towards the arrears, just, so they don't continue to increase throughout the case. I have other clients that are just stashing money aside, knowing that, they're probably going to have to move. They're putting that towards, moving and, first and, security for a new place. I have other people that just, they don't know what they're going to do. And, they're still not receiving any income throughout the duration of the case.
Yeah.
So I guess, so what typically happens, I guess? Because obviously, I guess people have a perception of housing court where it's like, you can't pay rent, but it's going to take them a really long time to evict you. And at the end of the day, those arrears are going to be piling up. But if you have no intention of ever paying them, you get a couple of months of free rent, and then it just shakes out how it shakes out. That seems like that's like a impression that you get from just, not knowing shit. So, what I'm saying? I guess clarify the misconception.
I think that brings it back to the one-shot deal.
Okay.
You know, so the standard for the one-shot generally is, you know, when you go to apply is you have to demonstrate that you had a legitimate hardship and that you have the future ability to pay rent. And, you know, if you can demonstrate those two things, you might get lucky enough to get a grant from HRA to pay off the arrears to keep you in your home.
Okay, and the grant could be for all your arrears?
So real quick, just to clarify, the one-shot deal is a loan. So that you get the money from HRA, but there's an agreement that you will pay HRA back over time.
In criminal court, it's very simple. You did a crime, and we trying to fuck you for it. Like, it's not rocket, like, it's not complicated. Obviously, what crime you committed changes a lot, but it's still always a crime. Where it's housing court, you might be there for so many different reasons, and I guess that changes how things flow. But I think what's best is understanding the commonalities in the process. So, and I think what you're explaining is that when it first begins, there might be many ways in which you can extend the process, not purely just to extend it, but for valid reasons. And that's going to be that beginning process, right? And but also while that's occurring, there's going to be
Arrears. So, you know, when you owe money for your apartment, it's called rent, right? But when these proceedings are happening, they call it use and occupancy. So basically, you know, the thought is you're living and using this apartment while this is going on. So you're still, you know, on the hook to pay, you know, rent, but it's called use and occupancy while the proceeding's going on.
Okay. And yeah, I mean, I can't imagine myself having the discipline to have extra money in my account that I know can't touch that. That doesn't seem so like, and it's all gonna shake out at the. So it's kind of weird because this occurs at the beginning of the case. It starts. Your rent goes from rent to arrears, or maybe you weren't paying in the first place, but now there's what you owed, and now you owe the arrears. When it shakes out the end, you said one way you can resolve the arrears is one shot. Can it get negotiated? Like what typically happens to whatever reason you were in housing court, for you to get back yourself into a normal lease status, you have to pay back your arrears as part of your resolution? Like, how does it resolve itself at the end typically?
Really, there's no typical outcome. The Right to Counsel program has really thrown a wrench in everything, because before us, it was just landlords and tenants. And before us, they would be signing stipulations to move out on the first court appearance. And those stipulations were, you owe this money and you're going to get maybe 2 months to pay it. And if you don't, we'll evict you. And then we come into it and then we throw a whole wrench to it and we're litigating. So it gives us leverage to bargain and negotiate for more favorable settlements. So what I see often a lot, I'm the adversarial type of lawyer. I'm going to file the pretrial motions. I'm going to posture that we're going to trial. I'm going to find whatever defense I can muster up. And if my client wants time, I'm going to do all of that, and it's going to take forever. What that also gives me is the opportunity to negotiate a stipulation that's favorable to settle the case, first day, second day, whenever. And what I see is some attorneys do, whose clients are interested in moving out and in moving forward with their life and not wasting their time in courts, is they will sign an agreement that says, I'll move out in 90 days if you waive use and occupancy and the arrears. So basically,
What's the difference?
The arrears is what you owe, use and occupancy is what's accruing during the time frame of the trial or the proceeding.
Oh, okay.
Right? So like he said, while you're in court, it's not a freebie. You're still getting charged rent.
Okay, so arrears is what you owed before you got into housing court. Use and occupancy is what you owe while in housing court.
Yes, what's accruing during that time frame.
Okay.
And there are things that can mitigate that too, such as if you have, you know, conditions in your apartment that are being repaired, you can request what's called an abatement. Sometimes a landlord will, acknowledge that those problems exist, especially when somebody has made a report to 311 and inspector came out and issued violations for those things.
And that's called warranty of habitability, right?
Yeah.
Right.
So I guess let's talk. I know we're jumping around, but let's just go down that lane real quick.
Yeah.
Explain warranty of habitability, what's covered, and how does that? Because warranty of habitability, saying it really bad, sorry, will get people into housing court, and that's probably very few times in which tenants are the people bringing the cases.
Yeah.
So explain warrant of habitability.
So I'd like to touch on this because this is something that my unit specifically focuses on a lot, where you have tenants who are rent striking. So the warranty of habitability is implied in every single lease, which is basically that you have the right to have a healthy, dignified, safe home. That's the premise. And if the landlord fails to provide a healthy, dignified, safe home, free from conditions, then they have, for all intents and purposes, breached the lease. So legally speaking, if you breach the lease, then there's no lease and the tenant doesn't owe rent. Now, let's be very clear. That does not mean that you won't owe rent. That means that they're gonna sue you in housing court for non-payment, assuming you have a lease. When they bring you into case, you can raise the defense that they did not make repairs. And that entitles you to a rent abatement hearing where you would litigate and show the court that these are the conditions that have existed in the apartment for this time period to this extent, and therefore you should reduce the amount of rent that is owed. Me personally, recently I got a great decision on this, NYCHA v. Barrett, where my client was living in deplorable conditions in Queensbridge houses, New York City Housing Authority, and egregious. And we were able to get a 100% abatement for his particular conditions. We're talking really, really bad conditions.
100% abatement. You only really see that when somebody's totally dispossessed, of the premises because the conditions are that bad. It's
yes,
tough.
But that is an outlier, right? Likely you'll get 20%, 30%, so on and so forth. So that is what entitles you to a rent abatement. It's implied within the warranty of habitability if the conditions aren't repaired. The thing is, that's a defense. You have to wait till they sue you.
Now it is like, 'cause I remember, maybe wrong or right, explaining to someone that if their conditions were really bad, what they could do is put their landlord on notice that they are going to withhold rent, which means save, right? Which means and I believe I read somewhere that you're supposed to put it in escrow. You could put your landlord on notice like, hey, I'm no longer going to pay rent until this gets fixed. I'm withholding rent because you violated this warranty. When you fix it, I will start paying rent again. And I guess in theory, if they fix it, you got to even pay them the back rent. Or I guess that's when it becomes, are they going to be abated or not abated? But you can do that up front. But then I guess eventually they'll sue you, I guess. Right?
Well, there's also HP proceedings. That's affirmative litigation that tenants can bring against their landlords for repairs. And we saw a lot of that during COVID when there was an eviction moratorium. A lot of legal service agencies shifted from
come on down. We're gonna fix these up.
Yeah, we shifted from eviction defense to bringing these HP and illegal lockout proceedings because landlords were getting upset that they weren't getting paid and they weren't doing repairs. They were illegally locking people out. So everything got flipped on its head, and it was a really strange time in housing court.
Well, one that really goes to show that if the court isn't being inundated with all these eviction cases, we can actually hold landlords accountable. And I just want to put that out there. And that's what we need. Less evictions, more accountability on landlords. And secondly, even in the HP actions, you cannot raise a breach of warranty of habitability issue. That's strictly for repairs. You're suing to get the repairs done. Alternatively, you can sue for harassment, which under the New York City Housing Maintenance Code is broadly the repeated failure to make repairs in order to get you out of the apartment. And there's a lot of different fact patterns that rise to that occasion, but you can get monetary, compensatory, and punitive damages for that. But that's not the same as a rent abatement. You can't ask for a rent abatement in an HB action. So with the warranty of habitability, you specifically have to make yourself vulnerable and rent strike so that you can get sued to get the rent abatement.
Okay. And go ahead.
So I actually did this once. This was my first apartment with the woman who's now my wife. So we left an apartment with like 8 roommates, and we moved into this place in Kew Gardens when I started at St. John's. And the apartment above us would let their like tub overflow, and the water would come in through our ceiling, and there would be like brown water dripping through the ceiling, and the ceiling was all cracked and messed up. And this was also like right when COVID started. So this was 2020, and I call my landlord, and we're writing them like texts and emails, so like this is all on record. But I'm also like just starting law school, so I'm in contracts.
With the wrong one.
Yeah. So I called the Legal Aid Society because I was like, I need to speak to a housing lawyer, but I can't afford one. Yeah. And they explained to me like the warranty of habitability and how I can call 311 and they'll send an inspector to my apartment and document the violations. So there'll be like a record from the government that these conditions exist. And so we do that, and I'm taking my Civ Pro exam at home, and my wife is just left to walk the dog, and the inspector knocks on the door, and I'm like, this could not be in the worst fucking time, because like I'm literally typing the exam, and I open the door, and there's this guy here, and he's got the HPD shirt on, and he's like, all right, what do I need to look at? I'm like, there's the bathroom, there's the roof, I mean, there's the ceiling, and I'm like, I gotta write this exam, and I go back, and I'm typing all this out, and then he leaves, and then my wife comes back, and she's like, did the guy come? And I go, yeah, he just left. And she was just like, did you show him around? I go, I can't talk to you. Like,
Civ Pro.
Do they have personal jurisdiction or not? I don't know.
Civ Pro sucks.
It was awful.
Yep. Civ Pro sucks.
But I passed and it's over. And then after it, I was like, yeah, we showed him around. It's fine. And they did issue the violations. But because of that, I had written him an email, and I was like, you are violating the warranty of habitability because there's water dripping from my ceiling, and it's gross and disgusting, and also a breach excuses performance, and I know that because I'm in contracts right now, and a breach on your end excuses performance on mine, so that means if you breach the warranty of habitability, I don't have to pay rent.
Yes.
And then a few months later, we found a new apartment, and we left, and I never paid that guy.
Nice. Good. How many months were you like, this apartment is not habitable?
God, I want to say like 4.
Woo!
Yeah.
Nice.
Yeah, so that was nice. But if you're dealing with conditions in your apartment, put the landlord on notice, put it in writing, send them an email, send them a text, call 311, get an HPD inspector in them, and withhold. And look for a new place if you can, but withhold the rent, put it in a separate account, or give it to an attorney, someone you can trust.
Yeah.
Okay.
Yeah, it's super important to like understand that like you want to save the money assuming that you have the money, because there is a universe where you're going to get sued in court, the judge issues a decision, they say, okay, you're entitled to a rent abatement, we're going to cut the rent by 20%, 30%, you have this arrears, they're just taking off the 20-30%. You still owe the remainder. So you'll get a discount, right, in the form of the abatement, but you have to be prepared to pay the difference, because if not, they can still evict you for the non-payment of that money that's remaining after the abatement. And that's actually a huge practical issue still for a lot of tenants, right? They still can't pay even after an abatement.
Yes. Okay. So then I guess, so as we were saying, so like I know we're skipping around to the beginning, but because we're still under arrears. When you resolve the issues in the middle, right, while you're in housing court, so many months has passed, you have the arrears / the payments within housing court. Does that typically throw a wrench in any progress you get in housing court? Like, I would imagine arrears are just insurmountable for some clients. And I guess, how do they get around that?
Well, one thing you have to consider with New York City specifically, it's different than any other jurisdiction in America because New York City has a right to shelter, and no other place in America has that. So there's a huge government interest in keeping people in their apartment, because if they leave, they go to shelter, and getting someone out of shelter or keeping them in shelter is much more expensive than just helping them out to keep them in the apartment. So that's why benefits like one-shot deal and FEPs and city FEPs save money for the government in the long run. So when the arrears have gotten crazy high and a person hasn't been able to save it, but they have a future ability to pay. So like I had a client, this is a client, we had to do 3 one-shot deal applications, but we got it through. The arrears weren't huge, like $8,000, but a typical working person can't afford to pay $8,000. But she was able to pay the rent, which was like $1,500, because she like got her education and she was now like working as like a dental hygienist. It's awesome. So she could pay like the $1,500, which was more than the rent, because this was a rent stabilized apartment and she had it for a while. So the government essentially gave her a loan for $8,000 to go to the landlord, and she'll pay the rent going forward, and she'll also pay that $8,000 back to the city over time. So it's a great deal for the city, because it's a whole family that keeps in their rent stabilized apartment. They don't have to enter the shelter system, and the city gets the money back.
Yeah, it's not bad.
Yeah.
So how much can you get on one-shot deals?
It
Depends.
yeah.
Can be, because I heard somewhere
They
someone
say-
said 40,000.
I just got one for 58.
Damn.
It's possible.
Yeah, I mean they try to tell you under 20, and if it's more than 20, they try to get contributions from other charitable agencies just to reduce the arrears. But depending on the facts and circumstances, you can get more.
Yeah. It requires, after the 20,000 threshold, a little bit more advocacy, because they're concerned more about the prospective ability to pay. They don't want to dole out 50, 60 grand and then you.
Now, who's getting a check?
I mean,
Who is it going straight to where it needs to go, or is
It's
someone
going-
getting it in their hands and saying,
it's going straight to the landlord.
oh, "Okay, that's good, I think." Because you give a guy $50,000, their morality is going to be
No,
tested.
it's going, and that's another common misconception. People think that it's going to the tenant. No, this money goes directly to the landlords, right? And whether that's good or not, that's a whole nother question. But I think your point with your client is very important to show like how effective having these one-shot deals and city FEPS applications at reducing the long-term costs. I would go even further and say like, just guarantee housing, right? Just pay for the housing. You're paying way more money having this whole bureaucratic administration of HRA, one-shot deals, and all that. Just pay for the housing.
So what's so funny is I watch a lot of Joe Rogan. I watch a lot of shows.
Yeah.
I could tell.
People talk about the housing crisis and homelessness and like fixing it, not fixing it, and like I think in hearing people talk about it so much at length, I think I know why no state, whether it's California or San Francisco or New York, is truly invested in whatever genius idea. Maybe there's a country that's figured it out, whatever, to actually fixing it. Because I think the reason is that if you actually fix it, however that method is, let's say we're taking over buildings in Manhattan, no one's using them, no one gives a fuck about offices, we're just making them apartments, one homeless person at a time. The problem you have is other states might sit there and go, get the fuck out of here. New York City cured homelessness, go live over there. And it's like, and if we're the only ones doing it, it becomes a thing where it's like, you go through a 6 or 8 month process, but you will have an apartment or home or whatever at the end of this process. It becomes almost too good, and it causes more issues than it does solve. I'm not saying that is the solution.
Let's get it straight. The government doesn't care about homelessness. They're in bed with the landlords. They're allowing these landlords to charge these exorbitant prices. They're in with the land developers, and they don't care about keeping roofs over people's heads. When in reality, like housing is right. Everybody deserves to have a roof over their head, but that's not what the government cares about. So I don't see a reality in which housing is ever fixed.
Yeah.
For that reason.
For that reason.
There was just a case in the Supreme Court. It was just argued that I believe it was this town in Oklahoma that made outdoor camping illegal in the town. So essentially, it gave their local government power to expel homeless people
From the town.
from the town, And that is why it's in the Supreme Court. Is like, can a jurisdiction essentially exile people for not being able?
It's illegal in the town. It sounds like I need to go to county jail before you tell me to get the fuck out of town.
And they're happy to pay for your health care in jail, for food. I mean, for all intents and purposes, it's hell housing, but you have a roof on your head. And they'll spend the resources and the money for the prison industrial complex, but they won't expend those resources for actually housing people and taking care of people and feeding people on the outside. So again, like you mentioned, this is an issue of choice, whether the government is interested in taking care of people and housing them. They are not.
Yeah.
And that's why it won't happen. I'm of the school of thought that it's going to happen because I have to take that prerogative in order to make it happen. I can't assume the alternative because then when is it ever going to happen, right?
Yeah.
So ultimately speaking, like, housing is a human right, and it needs to be constitutional, and hopefully one day it will. But you're seeing a lot of these types of cases is happening. It's happened in California with the houseless folks in the encampments. There's always been this sort of pending question of whether houseless people have the right to exist on the streets.
Yeah.
So I guess I know this is kind of like a broad, complex question, but if housing was a right, how would that function? Like, what would be the system to support that concept?
So something that's smaller than getting just housing as a human right is there's currently a law called the Faircloth Amendment. And the Faircloth Amendment is a law that from the 90s, it's named after Lodge Faircloth, who was a one-term representative from North Carolina. And it was signed by Bill Clinton. And it capped the number of public housing units available in America to the number it was at that time, which is a crazy thing. Like, imagine there was a law that said we can't build more schools that exist right now. And since then, we've stopped spending money on maintaining public housing, so the number of public housing units is actually much lower than it was when that artificial cap was put in place.
Also, justification of the cap.
Well, we can't be paying money on housing people in NYCHAs because, like, don't make me say it.
Yeah. I'll say it, racism. To be clear, public housing, when it was originally built, it was housing white people. Queensbridge houses was straight white. It was people coming back from the war, right? And then they utilized it as a tool to move towards the middle class. And then there was a lot of white flight from Queensbridge houses into various public housing. And at that point, that's when you started to see the institutional divestment from the federal to state to city level. And that's when they ultimately started allowing black and brown people to come in. Obviously, there was a lot of regulations, like they didn't allow single mothers and various things like that. But ultimately speaking, the fact that black and brown people started living in it is what led to the Faircloth Amendment, right? They won't say that. But they'll say it's a budget measure. We can't afford this, but that's classism, and that's ultimately classism is linked to race here in America specifically. So yes, to this date we have much less units, right, for public housing than what the Faircloth Amendment limited, and this actually been happening because of RAD conversions, rental assistance demonstration, which converts public housing to a more private version where they have private management, and they do that to sort of say, well, private management can make the repairs. The city and the state and the federal government won't have to foot that bill, right? And that's sort of the justification to remove it from being federally subsidized fully under Section 9. So that's all jargon, but ultimately I think the point is that, like, the vision that you talked about with the question was like how or why, public housing is the way that we can lead to affordable housing. Right? We have the solution. It's here. They just don't want to invest in it.
Okay. All right. I feel like we're almost halfway through housing court. but before we continue and get to the back end of, like, what you said, what part do you get sent to?
The trial part X is what they call it.
Before we get there, we're going to do a little segment that we do in the Treasury Swag. And just so you know, this is our, I didn't mention at the beginning, but this is our first episode of season 2. Very happy to be back. I hope you guys like the new podcast studio. We put a lot of work into it. Yeah. You guys are our inaugural guests, but this is the return of our favorite segment, Laws You Don't Know You Want to Know. Or Laws You Don't Know You Should Know. And on this episode, we've been very not landlord friendly, but we're going to be a little landlord friendly on this segment. And we're discussing exactly, and this to be clear, this is how, as a landlord or a homeowner, you could avoid squatters. Squatters have been in the news recently, and I know you guys, we discussed it earlier. The definition of a squatter is very important, and I think a nefarious landlord would like to label a legal tenant a squatter as a means to get them out or demonize them. But we're not talking about that. We're talking about a true squatter, true someone breaking into your home, and then the law that's going to make them go to the land housing process would be tenant rights that start at 30 days, right? So at 30 days, what basically happens is if you're in a home or you can prove that you're living in that home, whether you have a lease or not, as long as you can prove that you were living there, and ways that squatters, and this is a squatter, defining a squatter as someone who breaks into a home, doesn't have permission or authority, doesn't have a lease, doesn't have any relationship with the homeowner, but sees that the place is vacant, gets into the home, establishes tenancy there in the sense that like they prove that they've been there for 30 days, and at 30 days, they get the same rights as any other tenant, someone who's been given permission, such as a leaseholder, or just someone who's been allowed to stay there. So basically, as a homeowner, what you want to do is basically prevent them from establishing that 30-day mark, so that they just get arrested for being a trespasser, as compared to being given all these additional rights that basically makes it a very long process to evict this squatter from your home. Because, and like I said, what we're talking about, like I see someone in the news, they had just purchased a home and then found out someone was living there. And they made the mistake of, as you guys could discuss, they made this, once this person got the 30 days of the rights as a tenant, they made the mistake of changing the locks, which is a crime once someone has tenant rights. Once someone has tenant rights, you can't just change the locks on them, whether you perceive them to be a squatter or not. Because once they have those tenant rights, you have to treat them like a tenant, right? Does that make sense?
Yeah.
All right. So you're basically trying to make them not tenants. So the these are this list of top 10 things. What you want to do is regularly inspect the property, right? Because the whole idea is that they basically are there long enough to not go notice for a period of time, and they end up proving it was past 30 days. Regularly inspect the property. You want to enhance security. Supposedly clear signage for some reason, clear no trespassing signage is somehow really important. I guess the idea is that you're giving them notice that by them entering your apartment, they're trespassing, which I would think is common sense. But what I'm realizing in doing research for this is that it really, after going through down this list, what it comes down to is what the cop thinks when the cop is called, right? Because when the cop is called to the apartment to go, hey, this person's not supposed to be here, this person is a quote-unquote trespasser. If the cop doesn't believe they're trespassing, because this person argued, no, I've been living here for how many days or whatever, and they say, take it to housing court, that person has tenant rights. That person is not going to go through the quick process of just being arrested and taken out of your home. They're going to go through the long process of an eviction, right? That's basically accurate?
So I think my understanding, they just recently amended or added a law to speak about what a squatter specifically is. And if I understand correctly, I haven't looked at the statute in a while. Yes, it was passed. The statute was passed.
Oh, wow, okay.
About this. And from my understanding, it's 30 days. Before it was
10 days. No, it was 30 days. Yeah.
I think it might have been
Sorry.
A shorter time frame for them to get tenancy, and they made it a little bit longer. I don't know the exact time frame, but a statute was passed, referenced state law to see what the exact time frame is. If you looked it up and it's 30 days, then I would defer to you here, but ultimately I would discern that. But ultimately speaking, a squatter is a very specific thing, right? And I just want to make clear, as you mentioned, is that it's not someone who ever entered into the premises under a lease or the permission of a landlord.
Exactly.
Just because you don't, you're a tenant.
Yeah.
If you have a lease, or if your lease expired and you're a month-to-month tenant, for all intents and purposes, you are a tenant and you are afforded the rights and due process afforded in civil court. right?
Yeah.
And then recently, the landlord lobby did push for a law that was passed that reduced the amount of time which was required for you to have tenancy, right? And I don't know specifically what that statute is. I haven't looked at it. Honestly, it's not really an issue in housing court, to be frank, from my experience. The only time I ever saw an issue with respect to a so-called squatter was someone that was leased the premises by someone who didn't actually have title of the premises. So a lot of these people get stigmatized as so-called squatters, but they still came in under the guise of a lease. It's just that the owner of the premises didn't care about the property.
Yeah, so in doing research on developing this, we'll get to all of them, but what I could tell is that a common argument that someone who's labeled a squatter, and the question of whether they are a squatter is going to be, if they can establish they've been there for 30 days, is going to be something that's going to have to be argued in the housing court. A lot of times what they argue, and I'm taking them at their word, is that they were given a lease under false pretenses. Someone else who doesn't have permissive authority to make or give leases for the apartment gives them under lease under scam, basically. Yeah. But it's weird because it's a scam, but this person was able to get you in, has keys to the apartment, so it becomes a very weird, it's a very interesting scam. You could argue that I might give my best friend the keys to my house, say, hey, get me enough first time rents for a bunch of people, and I'm later going to come down the pipe and call them squatters and get them kicked out. Like it almost seems like that could be the scam. Cause I don't understand how someone who's scamming you out of a fake lease somehow got the apartments to my house without me knowing. That's what I'm a little confused about.
And that's why I think tenant advocates and tenant lawyers were concerned about this whole propaganda around this squatter issue, because I never seen it in housing court. Okay. It was not in housing court. And that was what it is, in my honest opinion. It was a propaganda campaign by the landlord lobby to try to undermine the tenants' rights as they currently exist. Exactly. You are entitled to due process. You have to go through civil court to get your tenant evicted. They are tired of that. And that's why they call people who don't pay rent squatters, because in their minds, that's what they think. If you don't pay rent and you're a squatter, you want them out. So they wanted this so-called squatter law, which undermined tenants' rights and their ability to have due process in court. I don't buy anything about the legitimacy of that. I think that there might be issues where people come in, like maybe just like run up into the house, break into it, secure it, and then make it their own. But that is such an anomaly.
Yeah, it does seem like something that's probably a low percentage.
Mm-hmm. Yeah, I've been doing this for 10 years and I haven't seen it, you know. But at the end of the day, being a landlord, it's not a real job. Housing is a human right. Guys. Like everybody deserves a roof over their head.
Yeah, so that's another thing that I feel like is missing from this whole conversation, is that what is happening where there's this vacant unit, in this hypothetical where there is a squatter breaking into a vacant unit. Why is it okay for someone to hoard housing and prevent someone from entering it who needs it? And also, this never has to come to housing court. Like if a landlord who owns multiple properties, which is, I think, the only reasonable way, not ethical, but reasonable way that someone could be like, yeah, I had that property and I kept it vacant for months because I was looking for like a tenant or something. Just go up to them and be like, hey, I'll give you $2,000 to leave. Like this whole thing, you don't have to go to housing court. This could have just really been negotiated between you if you looked at that person as a human being. But you decide to go to housing court and then try to like use the law against this person who's in need of shelter.
Right, and go pay an attorney that money that could have just been given to that person to secure.
That makes sense.
Yeah.
Well, for the sanctity of the segment, because it sounds like you guys are saying
you invited the wrong people.
You invited the wrong people. This is not the crowd.
No. I kind of knew that I was barking up the wrong tree, but I thought it would be interesting anyway. But assuming this squatter is real, because now we're not sure if they're real, but assuming they were real, clear signage, maintain the appearances of occupancy, right? Because you're trying to ward up. in this hypothetical, you're
Rent
kind
the
of more-
apartment. Just rent the apartment for a fair price, and maybe
Or
you won't
sell
be
the
vacant.
house.
Sell the house.
Yeah.
So do something,
Yes.
right?
Housing shouldn't be commodified.
Yeah.
No, 3 months
That
Hawaii,
part. That
you
part.
can't do that. No 3 months in Hawaii, because at that point, what they're saying is fucking give it to someone who needs it.
Yeah.
But like that's for real. Like I know you want to make your point, but we have to say it here. Like, why are we hoarding this wealth? Why are we hoarding these houses? They shouldn't be commodities. It should be for housing. The landlords love to claim, oh, I want to rent my apartments, I want to rent my houses. So why is it vacant for a year? What are you doing with that?
We need
I
a
mean-
vacancy tax.
Listen, we saw a great example of that stuff with the 2019 HSTPA. That basically said that vacancy increases were no longer allowed. So in the past, when a new tenant came into a rent stabilized apartment, they were able to increase the rent much more than if it was just a tenant who was staying there. So it encouraged them to push people out, get new tenants in, not issue succession rights, things of that sort. HSTPA of 2019 said that's no longer allowed. A lot of landlords were like, you know what? We're going to fight this law. We're going to take it up on appeal. So we're just going to sit on this housing, not re-let it. It's just sitting vacant in the hopes that this law gets overturned and then we can increase the rents.
All right, you hear that, motherfuckers? Squatters ain't real. That's what I'm getting.
There
When I
we
get
go.
into the list,
Yeah.
the one that I actually thought was good. 'Cause, like I said, I've had. So the funny thing is, I've had criminal clients, right? Who
Alleged criminals.
clients who accused of crimes, right, in criminal court, who have basically said that this was happening to them. That this guy, under whatever pretense, it's usually, but the thing is, it's rare squatters, it's usually a holdover. But basically, they take over their apartments. I have a lot of clients who apartments are taken over using the criminal justice system. But that's not really squatters. It's more like I'm a tenant or like I'm subleasing, and then I accuse you of a crime, so then there's a full order of protection, and then you can't go back to your own apartment. So it's not really squatters, but I get a lot of cases in which it's not really the landlord, it's more really the tenant, and then the other person's a subleaser, but they're the ones with the lease getting fucked one way or the other by this person using full order protections as a sword as compared to a shield. But the one of these lists, because I think we can just move on, that it seemed like it was a good argument, because like I said, basically what's going to happen is the cops are going to show up. They're either going to believe the quote unquote squatter that they lived there longer than 30 days, and they go about proving that one way or the other, or they're going to believe the person saying this is a trespasser, right? And what they basically said is that, hey, if you're going to be gone long enough, go to your local precinct and go, hey, my apartment's currently vacant, prove that it's vacant, I'm going to be gone, but if I come back and someone in there, I'm not giving leases in the next couple of months. So if I come back and I say this person's a trespasser, that's my proof. But like you said, this is not really happening.
It's not, and abolish police.
Probably, I got you. All right. So let's get back to where we were at, which is that like the trial parts, right? So explain how that works. So you work through your motions, and then what are these trials typically about? How do they get resolved?
So it depends on what the landlord has to prove. In a non-pay, it's that the landlord needs to prove that they are the landlord, that this person resides in the apartment, and that they haven't paid this amount of money. If it's a holdover, they have to prove again, I am the landlord, this person is in the apartment without my permission, or they're doing something and I want them to leave. And then at trial, they just have to prove those facts. And that's one of the reasons trial is difficult for us as tenant advocates, is it's really easy to prove you're the landlord. We can get into some intricate stuff like you submitted this deed and try to go through the business records exception. But really, if the landlord can prove that they're the landlord and that they don't want this person there, that's it. and then we lose the case. They get a order of eviction or a warrant of eviction. They post the marshal's notice, and then 14 days later, the sheriff can execute the eviction. And all we can do then is do orders to show cause to try to delay it.
So what would be orders of show cause? Like what would the arguments in those orders of show cause be?
I mean, you know, the trial decision comes down. Somebody has to move out by, you know, June, the end of June, right? They're looking for housing. They're finally able to secure housing, but it's not until, you know, July 15th or August 1st. They come to court. They say, "Here, look, I have a lease, you know, for, you know, this new property. I can move. However, I need a little bit more time to, you know, allow me to, you know, move with dignity." You know, that's one of the most, you know, common ones that are granted, at least.
Yeah, good cause is it, and there's a whole bunch of reasons why, but I'd like to take a step back in terms of the trial and what the landlord has to prove. The most litigious cases at trial are the ones where we have substantive defenses, and I want to let the people know about what the defenses exist for tenants, right? One of the most potent defenses is de facto rent stabilization, right? De facto rent stabilization, as I mentioned earlier, there are rent stabilization laws in New York State. If there's a building that has 6 or more units that was built before 1974, and now case law has shown it doesn't even need to be built before 1974. If you have 6 or more units, you are subject to the rent stabilization law. There's a nuance point. It's not just about 6 units, but if you have 6 single room occupancies, meaning, and this is very prevalent in Queens amongst these houses, right? What people do is they'll rent out rooms. So if you have 6 rooms rented out, and we find that out, I'm constantly looking for that as a tenant attorney. Well, how many people are living here? Is there 6 people living here? Are they paying rent separately? Do they have separate rooms? Do they have separate keys? That's a potential defense that can vitiate a holdover proceeding, saying that you don't have a lease. Because if it is de facto rent stabilized, then you are entitled to a lease renewal. Right? So they should have never even brought a holdover to begin with. It should have been, assuming rent is owed, a non-payment. So that's one defense, right? De facto rent stabilization. Another defense is retaliatory eviction. Now, let's say in a holdover where you don't have a lease and your landlord sues you because you don't have a lease and they want you out. If you filed a complaint before they issued you a predicate notice, the 30 or 60, 90-day notice of eviction, right? To 311, to the landlord, if you filed a complaint about conditions, you can say that this was retaliatory, and it's a rebuttable presumption saying that the court assumes that it's true, and now it's the landlord's burden to show that this wasn't done because you filed the complaint, but for some other reason. And that's something that you would litigate at trial, right? So in addition to the de facto rent stabilization and retaliation, there's also, am I missing this one? There's several more, but those are 2 important ones that I would take into account, and that would extend the time frame of litigation, right? The same way in a non-payment, you can raise the warranty of habitability, and that would be litigated in the trial part. So we're going through evidentiary proceedings, we're doing direct, we're doing cross, in those instances where we have defenses. And the litigious ones are ones where we have those defenses. Otherwise, if it's, like you mentioned, if there's no defense, it's, are you the owner and do they have a lease? Are you the owner, or if they didn't pay? So it's good to know there are defenses out there that do exist, and tenants are entitled to raise those defenses and speak to counsel about it and preserve those defenses when they file their answers once they get the first petition and the notice of petition, because you have to respond to it. And if you can't file a motion, you can write your answer in, and you could be like, well, they didn't make repairs, or I believe there's 6 or more people living here. The thing is, tenants don't know that they have the right to potentially rent stabilization if there's 6 or more people living in the
And it has to be preserved in your answer, or
if
you're
it's
fucked?
basically at trial. You can make a motion to amend the answer at that juncture, but what tenant knows that they can make a motion to amend the answer?
I mean, I would imagine if you somehow make it to the trial part and you still haven't given a counsel, you don't know what the fuck you're doing. Like, and does that happen a lot? Like, what percentage of people are at that stage with no attorney?
So I feel, and what I see in housing court is that people who do not have an attorney essentially get bullied by the landlord's attorney into agreeing into a stipulation that they don't have to, and they really don't understand. Just because they don't have an attorney. And I see the landlord's attorneys straight up lie to them and say like, hey, if this was my case, I would just want this out of the court system because I know wouldn't have any defenses. And that's what I'm telling you as a lawyer. Like, I've heard them say that to tenants.
Damn, that's fucked up.
Yeah.
And one big,
You need to do a sting operation. Get those motherfuckers disbarred.
and that's the thing is that like that's about 90% to answer your question. That's about 90% of the tenants that are present, right? That don't know this and are going through this process and making these agreements.
90% of the population in housing court don't have counsel?
No, not that they don't have counsel. Is that amongst the ones that don't have counsel?
Oh, okay. That's
Yes, amongst the ones that don't have counsel, right?
They
They get bullied into making these agreements because they don't know their rights.
I mean, I think, that leads us to having to discuss how the resolution part is conducted. It's a total mess. At least in Queens, you have, 4 resolution parts. They could have between 40 and, 70 cases on the calendar for a particular day.
Just to take a step back so I can visualize it. There's a trial part, there's a resolution part after trial before
Result was first.
Huh?
That's the first part. Pre-trial practice is happening in the resolution part.
And to help you further visualize this, every day in Brooklyn, there's a line like blocks long of people trying to get into housing court.
Okay.
And in Queens, there'll be like, 50 to 100 people in housing court every day. And the hallways are just filled with people. It's landlord attorneys yelling at tenants.
Yeah, I was there in Manhattan. I can tell this is wild. But so the resolution part, is that also the same part that you were talking about in the beginning where you can file motions? And
Yes.
Stuff like that?
Yes.
Oh, okay, all right.
So that's got, 40 to 60 cases in one room, 40 to 60 cases in another room. Those are both conferenced in one room together. So you have all the litigants and, the few attorneys. Most of the landlords have attorneys. A lot of the tenants do not. And, they're on the court calendar for 9:30, 10:30. But you have all these cases to deal with. So basically, the landlord's attorneys are just calling out people's names. If they have an attorney, they hold off sometimes. They're supposed to speak with that tenant's attorney. Otherwise, they try to strike up a deal with the tenant without the involvement of the court. They're supposed to tell them, I'm not your attorney, I'm the landlord's attorney, I can't advise you. Doesn't always happen. So a lot of the time, deals get entered into, there's an agreement that's signed and then just submitted to the judge's court attorney who sits in the resolution part. So these tenants sign away their rights without even speaking to a judge.
That's fucking scary.
There is the back end where once they sign these agreements, they go in front of the judge to allocute. It's called an allocution. And the judges are then required to let the tenants know, like, do you understand that if you sign this agreement, you're foregoing your rights to trial and so on and so forth. But the thing is, they don't really understand the degree of the rights that they're forfeiting anyway, right? And then a lot of the times, these landlord attorneys posture as decent people who are trying to help you out. It's like a good cop, bad cop situation. You're in a bad situation. You need help. A landlord's attorney comes and presents, oh, you need time? I can give you time. How much time you need? I need 3 months. Okay, cool. They sign up and says, okay, so judgment of possession, right? Warrant issued forthwith. They don't have to issue a 14-day notice, and you owe X amount of money. And they think they got a deal because they got 3 months. But you put us on the case and we file a motion, you'll get more than that, right? And the first day is particularly retained to getting counsel. So some people will come in and you'll have pretty zealous landlord attorneys try to get you to agree on that first court date to a settlement, because that's what they're used to before we came into the picture. They're mad that we're here now, right? But we're here to stay and we're going to keep on fighting. right? One thing I want to say also, because we were talking about the trial part, another defense for non-payment specifically is not having a lease, right? And alternatively, not having a valid certificate of occupancy, which is very important to know. Under the certificate of occupancy is required for multiple dwellings where you have, backtracked. Certificate of occupancy is required for all buildings in the city that were built, I think, after 1920 something. I forget the specific year. But without a certificate of occupancy, you cannot proceed with a non-payment. Basically, you don't owe rent for the time frame that you didn't have a certificate of occupancy. So to all the people watching, go to whoownswhat.org, type in your address, right? Go to the Department of Buildings link, click where it says view certificate of occupancy to see whether or not the premises has a valid certificate of occupancy.
Yeah, I mean, let's stay on the topic of who owns what. That's a fantastic resource for tenants and tenants attorneys. You put in your address, pulls up DOB records, it pulls up HPD records, so you can see violations that have been issued. You get access to so much information that is really, really, invaluable.
Yeah, and in addition to that, I mentioned multiple dwelling because I generally conflate the two, but these are two separate things. Certificate of occupancy is one thing that can prevent your landlord from proceeding with a non-payment. Alternatively, under the multiple dwelling law, if you have a building that has more than 2 units, it's supposed to be registered with HPD, Housing Preservation and Development of New York City. If it's not registered, then they cannot also get the rent that's owed on the apartment. So those are 2 ways that you can potentially not owe any rental arrears: not having a valid certificate of occupancy and not a landlord not properly registering their apartment if it's a multiple dwelling.
And with C of O issues also, it's important to note there's a lot of basement apartments that are illegal that there's not a proper certificate of occupancy for. So there's a number of issues with that.
Yeah.
Now, to play devil's advocate, and what I mean devil's advocate, to see if there's a huge scam in lying in here. If let's say for example, I get into housing court for habitability issues, the arrears, and what's the one that's in housing court? What's that?
Use and occupancy.
You can occupancy.
Yeah.
Is that negated by?
Yes.
That is negated by.
No certificate of occupancy, no registration, no use in occupancy, no rent.
So, like I said, I'm not saying you do this, guys. I'm just, my mind is churning. If I know that my current residence, right, doesn't have something that negates my need to owe them rent, and I get this case into a 16-month housing court situation, right? Because you gotta think about it. Like, you guys are saying, hey, if you know this is true, don't pay your rent and put your landlord on.
We didn't say that. We didn't say don't pay your rent. Let's be very clear. We're saying that if a landlord sues you for non-payment in housing court and they don't have a valid certificate of occupancy, then that's a defense to the use and occupancy and the arrears that you owe.
Yes, exactly.
That's what I'm saying.
Yes.
Right, and I'm anticipating your question. And one of the defenses to that, a counter to that, is if you moved into a premises knowing that there was no valid certificate of occupancy, then you are barred from raising that defense.
Okay.
If you knew.
If you know. Okay.
If
That's
you
what I'm saying.
did not know and you magically stopped paying rent because you couldn't afford the rent, that does not preclude you from that defense.
Okay. Yeah. Because it seems like I would purposely rent an apartment that doesn't have that, then get myself into housing court, in which I'm supposed to be saving all these use payments, months and months of use payments, and then at the end of it, sit there and go, oh, trump card, I never had to pay this, and I wouldn't have to pay it, right? In theory.
If you didn't owe, if you owe the money and you didn't know about that C of O, certificate of occupancy, or the registration, that is a defense and it bars them from collecting payment. And obviously, there's always different facts and nuances, but that is the general law.
Important to note, it's not collectible in housing court.
Okay. Oh, so what does that mean?
So, there's numerous circumstances where a landlord could take you to small claims court for money owed. However, the distinction there is they cannot get a warrant of eviction. So, there's cases where, money will be either, waived or severed for a plenary action, so it gives the landlord the opportunity to still seek that money from that person. They just can't evict over that amount.
Oh, okay. All right.
And it's a serious issue. It particularly impacts the immigrant community in Queens because they end up not knowing the law or the legal system in America and end up needing cheap housing and moving into these illegal basement units.
Yeah.
And then it floods and there's a lot of deaths that happen because of that. Also, they end up in housing court and don't know that they've been living in an illegal apartment for so long and have been paying rent for an illegal apartment. And also, I had a case, this was when I was in my clinic, where a guy called in, called our hotline, he was living in an illegal basement. It flooded, his landlord just changed the locks. And he just didn't know what to do. He called me from a playground. And
So that's a good segue because what has the immigration crisis, how has that affected housing court because I know it implicates right to shelter, allows a lot of people coming to the city who don't know their housing rights. So what has been the effect in terms of you guys' jobs, in terms of dealing with maybe more of your clients are people who've recently immigrated to the city? What has been that effect?
It's bad. I was just talking about this earlier. I have this client who is in his 60s. He was undocumented immigrant working as a construction worker. He gets into housing court because he got sick, was out of work for a little bit. Turns out that his apartment should have been rent stabilized. We went through tons of litigation, discovery, depositions. We established that it should have been rent stabilized. However, during the course of the litigation, his arrears shot up to about $80,000. On top of that, he had to have both legs amputated. So he had no means of, getting any income. Because he was undocumented, he wasn't eligible for any benefits. And we won him a rent stabilized apartment, but he couldn't afford it.
Damn.
Yeah. Yeah, it's a real big problem because there are folks who are undocumented, and one of the vouchers that a lot of us depend on, city FEPs, one of the means of achieving city FEPs is by getting into the shelter system, right? And even if we were to get them into the shelter system, right, they may still be barred because of their immigration status, right? So it's, in addition to that, the one-shots, you also, from my understanding, require some form of immigration status. I don't think you necessarily need to be a citizen, but you need to have some form of immigration status as well. So we can litigate non-payments, but at the end of the road, if we can't get the money, or if we can't find a voucher to get them housing somehow, then they're shit out of luck. As much as the most that we can do at that point is functionally buy them time.
Shit. All right. That's not a good way to end the episode.
No, absolutely not.
All right. So I guess what do you guys think? Right to counsel seems like just the beginning. Where do you guys think it's going? It seems like obviously all these agencies that provide housing counsel need increased funding. Yeah. It seems like there's definitely not enough money in the system. Do you guys see any big changes on the horizon?
We need, first of all, less eviction cases. But aside from that, we need, more funding in legal service agencies to fund right to counsel, so people aren't falling through the cracks. but also bigger picture, a lot of laws need to change. It's still structured to help landlords over tenants, despite how much the landlords want to cry and complain that all these tenants are taking their money. The system is set up for tenants to fail, and with the price of housing just continuing to go up, I unfortunately don't see any big changes in sight. I hope that it does happen, but it's hard.
Yeah. I think that this is not just a legal question, it's a political question. It's a question of political will. What is the city, state, and federal governments willing to do? They passed the right to counsel in 2018, if I understand correctly, and there are challenges with the bill, and largely it is funding, right? So from the political standpoint, when we prioritize tenants and housing as a human right, as a principle, then the law will reflect that. As it exists now, it's property is the central right that is being protected, and everything around it is just due process for tenants before they get thrown out, right? The assumption is you don't have a right to housing. We say housing is a human right, but that's not in the Constitution, that's not in the state law, it's not in the city law. So until we fundamentally move away from protecting property rights to protecting housing rights, everything that we do is going to be piecemeal. And we see that because that's what the right to counsel is, ultimately speaking. In addition to the political question, if it's going to be a legal solution, I mentioned earlier, we need a civil Gideon. We need a constitutional right to a housing lawyer. To all civil cases, frankly, in my opinion, but particularly in housing. If we don't have a constitutional right to housing, then to what extent do we have a right to housing? So that's one way that we can check the right to property that landlords have, right? And the fact that their property gives them money that allows them to influence the party, to allow them to influence the judges that are appointed, that allow them to influence inadvertently how these judges make decisions on landlord and tenant law. So those are really the two things, right? The political question, right? Do we have the will to say housing is a human right and we need to move away from protecting property to protecting housing? And then from a legal framework is how can we constitutionalize the right to attorney for tenants?
So I was watching this video about hermit crabs, and
I'm looking forward to this. Yeah.
So like hermit crabs, as they grow up, they form a line of like all the hermit crabs, and they just switch shells, like 1 to 1 to 1. Like the smallest one moves into the second largest one, and it's really cool. But that's not how we're supposed to live. Like we need to be able to live and build families and build communities in our homes. And the landlord class wants us moving around every 2 or 3 years, not having any connections with our neighbors, not having any solidarity among our neighborhoods. And so we have to, as working class people, come together and fight the landlord class so that we can have greater protections in our homes and greater protections in our neighborhoods, and also build a lot more housing. We need a lot more housing in New York City, and not just apartments, condos, co-ops, places where working class New Yorkers can own their homes, not have to worry about being taken to housing court, and build wealth between their generations. Not having to give 1/3 to 1/2 to 2/3 of our income every month to a landlord. Being able to build that wealth in our families and pass it in to our children and our children's children. Yeah.
So we got work to do, basically.
Yeah.
Well, these conversations like this, I hope, are a step in the right direction. Yeah. I'm really happy you guys are here. Before we segue out of here, any wise you want to shout out, drop your Instagram, anything like that?
Yeah, I got 3. There's an election going on right now. Early voting is already up. So vote. Getting left-wing politicians got us the 2019 HSTPA and the right to counsel. We need to keep electing pro-tenant, pro-working class politicians. Second is Brooklyn Eviction Defense. If you're in Brooklyn, there's a tenant union called Brooklyn Eviction Defense that does great work. They have a website and WhatsApp community where people can go and ask questions about dealing with their landlord and housing court. And third is DSA and NYC. We're trying to do a lot more with tenant unions around the city and tenant education. We're building monthly tenant circles where tenants can call in or show up at the NYC office to talk about issues in their apartment.
Dope.
Yes, we got to shout out UAW 2320 and 2325.
Yeah, go on strike and get paid more. You deserve it.
We all need that pay increase.
But shout out to all the tenant unions throughout the city and the tenant associations that exist specifically throughout the public housing projects here in Western Queens and throughout the city. Astoria Tenants Union, definitely get involved with Astoria Tenants Union if you're in Astoria. And definitely check me out at Dannelly Rodriguez.esq, the people's lawyer, you know the vibes. We outside.
We outside, baby. Well, that's the first episode. If you like,
Hey! You gave your shout outs?
Yeah, give my shout outs.
Oh my God, my apologies.
it's all right.
I'm sorry.
No, I appreciate you caring about everyone. That's the type of vibe we like to turn into swag. Well, that's the first episode. If you like what you saw, please like, comment, tell us what kind of episodes you want to see in the future. Check out our merch shop. Make sure you subscribe to our YouTube page. That's Tony the Sag. We out.
Should've seen it coming like a prophecy. Cause the work got us moving with velocity. We beastin' now, it's a monstrosity. We the plug to the source, unshockingly. Wow, what's he really gonna do now? Jolts in your system better stay on the ground. Volts in the circus is a spark to the sound. The energy that entered me are jewels in my crown. Wow, that's how it's always gonna be. You'll never really get it like NRG. Could do without the static and the flattery. Chill for I catch a charge like battery.
No style, what? Turn your energy up. No work, what? Turn your energy up. Too wild, turn your energy up. Turn your energy up. Turn your energy up. No style, what? Turn your energy up. No work, what? Turn your energy up. Too wild, turn your energy up. Turn your energy up. Turn your energy up. No style, what? Turn your energy up. No work, what? Turn your energy up. Too wild, turn your energy up. Turn your energy up. Turn your energy up. No style, what? Turn your energy up. No work, what? Turn your energy up. Too wild, turn your energy up. Turn your energy up. Turn your energy up. No weakness, just energy. Just energy. Just energy. No weakness, just energy. Energy. Just energy. No weakness, just energy. Just energy. Just energy. No weakness, just energy. Energy, just energy. No weakness, just energy. Just energy, just energy. No weakness, just energy. Energy, just energy.